This video looks at human rights, in particular the Queensland human rights legislation and gender-based discrimination. You would have noticed in the video that looked at anti-discrimination legislation that at the Commonwealth level, our anti-discrimination legislation is an implementation of international covenants, in particular the covenant on the elimination of all forms of discrimination against women. In Queensland, the government did not need to hang its power to make legislation, anti-discrimination legislation, on an international covenant. However, they have more recently, and again without needing to apply an international covenant, created the Human Rights Act 2019. The Act was passed in 2019, but was only enforced from the 1st of January 2020. There was a long lag between when the Act was created in early 2019 until it was actually, the bulk of it was actually in force. Initially just the name of the Act and a few other minimal provisions were in force, and then the bulk of it came into force many months later. The Act is really a statement of intention and a format for government action. It does not itself create any cause of action for an individual. All the Act does is it allows for consideration to be applied for new legislation. The government has to show why or why not they're complying with the Human Rights Act. And where a court is interpreting legislation, if there is multiple possible interpretations of legislation which is ambiguous, then any interpretation that complies with the Human Rights Act is to be preferred over an interpretation that does not comply. However, the Act does not bind the government to only make legislation in accordance with the Human Rights Act. And as I said, there is no right for an individual to actually bring an action under the Human Rights Act. If they are already taking action, for example, an administrative appeal, then they may also use an argument based on the Human Rights Act that their human rights have been contravened. However, it by itself is not a cause of action. It does, however, create a strong normative standard that the government is to take into consideration. And part of that, and this is one of the key provisions, is that there is to be recognition and equality before the law, and that every person has the right to recognition as a person before the law, and this of course includes whatever their gender. Every person has the right to enjoy that person's human rights without discrimination. And every person is equal before the law and entitled to equal protection of the law without discrimination. Also, every person has the right to equal and effective protection against discrimination, and that measures for the purpose of assisting or advancing that do not themselves constitute discrimination. So assistance, for example, affirmative action programs for minority groups or gender and sexual minorities, etc., would not be discrimination, because if they give a little boost up to someone who is historically disadvantaged. So that's, you can read through the Act as a whole, but this is one of the really key parts for our Gender and the Law study. You can see that it is very much adopting the liberal notion of the individualized human's rights that can be compared to the rights of others, and that allow them to delineate their human rights against the actions of governments, etc. It doesn't act at a systemic level across groups of people. It's very much about the human rights of an individual. That very small L liberal theory construction of the legal subject that we're also used to throughout law. It very much fits the model of liberal feminism, and other areas of feminism, such as radical feminism, would critique this as not actually attacking the systemic underlying patriarchal issues, but rather individualising those who are harmed by it.